Okay, we're calling to order the PSIPC November 18th Policy Committee Administrative Announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the policy committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once a staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. Calling for introductions of everybody.
When I call on you, please state your name and who you represent for the record. We'll start with you, Chair Lenzen.
Dan Lenzen, the chair of the PSIPC, Private Security.
Thank you. And then online we have Member Berg.
Good afternoon, Ken Berg, Medford, Oregon, representing the manufacturing industry.
Member Krieger.
Good afternoon, Scott Krager, representing entities that contract for security services.
Member Flaw.
Ed Flaw, representing Alarm Monitoring.
Member Nakasone.
Good afternoon, Nate Nakasone, representing Unarmed out of Portland.
Member Ralph.
Travis Ralph, representing Armed Security in Tampa, Florida right now.
Member Schultz.
Matthew Schultz, representing Healthcare Security out of Portland.
Member Snyder.
Helena Snyder, representing PI Subcommittee, if I'm not mistaken, now.
And it appears we're still waiting for Member Stone, so whenever he gets in, we'll introduce him. Now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Emma Detweiler, DPSST staff.
Susie Herring, DPSST.
Marie Atwood, DPSST.
Michael Holsapple, DPSST.
Carissa White, DPSST.
Jennifer Howell, DPSST.
And that's everyone.
Thank you. Has everyone had a chance to review the minutes from the previous meeting? If there are no requested modifications, I'm looking to confirm consensus of the previous meeting minutes, please.
Ken Berg for the record.
Oh,
I apologize. Go ahead.
please go.
I was just going to make the recommendation to accept as written.
Helena Snyder as well.
You know what's really
on our seconds.
we got to editorialize, Chair Lindsay. I got a script here. It's really cool, and this is awesome. I'm laughing, and I'm just following the script. I want to make sure that we're good here. And so, from the chair, confirmed committee consensus to approve meeting minutes or amended. Are there any objections? Hearing none, motion passes. And then turning over to our professional standards for the next topic, the proposed rule changes for the OARs.
Thank you.
I hope you don't mind that Member Stone did just enter. So if you would like to introduce yourself really quick, Member Stone.
Yeah, Member Stone, Hospitality. On my calendar, it said the meeting was starting right now. Is it not right now?
Oh, we just started about 5 minutes ago.
Okay.
Thank you. Sorry, Jennifer, back.
No problem. Thank you. Jennifer Howell for the record. So today we're looking at proposed rule changes within the private security provider rule set. Your memo outlines recommended rule changes regarding suspension and emergency suspension of private security provider certifications and licenses. For the record and for members of the public watching remotely, I wanted to start by reviewing terminology. The term private security provider includes three groups: the private security professionals, private security instructors, and the executive and supervisory managers. DPSST issues certifications to the professionals and to the instructors, and issues licenses to the managers. But for the purposes of the discussion, the terms certification and license can be used interchangeably. The intent of these rule changes is to strengthen DPSST's ability to take action in two sets of circumstances. The first, DPSST recommends taking action to suspend certification when any provider no longer meets the minimum standards for certification or licensure, and to issue an emergency suspension order when an armed professional or firearms instructor loses their legal eligibility to possess a firearm. Second, DPSST recommends taking action to issue an emergency suspension order when there's substantial evidence that an instructor has violated the responsibilities that are listed in Administrative Rule 259-060-0136. So right now, DPSST can deny, revoke, or refuse to renew a private security provider's certification if they fail to meet any applicable rule. However, during that process, the certification remains valid until the action becomes final. Under the Administrative Procedures Act and the Attorney General's model rules, DPSST also has the authority to issue an emergency suspension order, immediately suspending certification, if there's a serious danger to public health or safety. Emergency suspension orders are effective immediately. They don't require prior notice or a prior hearing. They prohibit the individual from performing private security services or instructing while the order is in effect. The order must state why there is a danger to public safety, and there is still due process after the order has been issued. The individual has the opportunity to request a hearing on the order, to contest the order. Like denial, revocation, and civil penalties, DPSST has identified in administrative rule when the agency will use suspension and emergency suspension authority. The already existing suspension and emergency suspension actions include cases where a provider is charged with a crime, and cases where an armed professional or a firearms instructor fails to meet armed training requirements. So in addition to strengthening DPSST's ability to act when there is a danger to public safety, these rule changes will provide transparency for constituents by identifying the circumstances that may result in suspension or emergency suspension, and building that connection between the certification and the potential danger to public safety. I wanted to walk through the administrative rules and then provide some additional bits of information. They begin on page 3. For organizational purposes, the rules are presented in numerical order, which is going to sound like I'm talking about the minimum standards and then inserting the instructor information and then going back to talking about the minimum standards again, just because that's the way that the numbers flow. So I just wanted to point out that there will be a bit of a back and forth between the two recommendations. Okay. So with the administrative rules, we started with rule number 20, the minimum standards for certification or licensure, and included this rule as reference for context. So this rule identifies statutory and board-approved standards for certification or licensure as a private security provider. Those things include age, education, completion of training, moral fitness, and the minimum standards for armed certifications. So adding the opportunity to suspend a certification or license will provide another tool to address non-compliance with these standards. A notice of intent to suspend is administered similarly to the denial or revocation. The suspension does not go into effect until the opportunity for a hearing and any contested case proceedings have been completed. So while it's important to ensure that all providers are in compliance with these minimum standards, the department's recommendation also includes that higher level of suspension, the emergency suspension for the armed minimum standards. And those are listed in that administrative rule in section 7, appearing at the top of page 5. These standards are related to that legal eligibility to possess a firearm. And the reasoning is that the department finds that if a certified armed private security professional or the private security firearms instructor no longer meets these minimum standards after their certification has been issued, there's a danger to public safety that rises to the level to require immediate suspension of the certification. Because the individual is no longer in compliance with the minimum standards, the department would initiate revocation process, but again, in that interim, the certification would be still active. So that's why elevating it to that emergency suspension level. And because these circumstances listed in section 7 don't always include being charged with a crime, they don't already cleanly fall under the current emergency suspension rules for being charged with a crime. So adding this specific emergency suspension rule will address that. Okay, so getting into the actual changes that are in the rule, the next rule there in the packet on page 5 is Rule 120. I should say the whole rule, 25906000120. Private security professional requirements for certification. And the change is shown on the bottom of page 6. This is adding in the connecting language. So it's recognizing non-compliance with the minimum standards and then connecting that to the action that would take place in rules 300, 310, and 320. So it's building that connection language. We're going to see the same thing in rule number 25906000130, private security executive manager and supervisory manager licensure and requirements. So building that connection. The next rule in your packet is Rule 25906000135. This is the private security instructor requirements for certification. And I know it all appears very lengthy, but we included the full rule so that all of the context was available in case it created a question with any other part. So in this rule for instructors, on page 12, section 6 is again building that connection to the minimum standards. That non-compliance could result in suspension under those rules 300, 310, and 320. Then in section 7, this is where you'll see the emergency suspension of the instructor certification. So to tell you a little bit more about that, the department certifies private security instructors to provide instruction to private security providers or applicants. Administrative Rule 25906000136 defines the duties and expectations of a certified private security instructor, which include first and foremost delivering the board-approved or department-accredited course curriculum in its entirety and meeting or exceeding the minimum number of training hours required for delivery of the course. When an instructor is violating these responsibilities, or the responsibilities listed in Rule 25906000136, but they're continuing to deliver the DPSST private security courses, there's a serious risk of harm to the applicants, the employers, and the public. When instructors falsify records, deviate from approved curriculum and minimum training hours, or otherwise violate the standards, this may result in certification of applicants who do not meet the minimum training standards required to perform private security services. The violations undermine the integrity of the regulatory program, they compromise public trust, and they increase risk of harm to public property and other security personnel. And so that is why the recommendation for the emergency suspension of instructor certifications and the language that is mirrors that here in the administrative rule on page 12. Okay, so the next rule is that private security instructor responsibility rule 136, and the change is at the end of that rule on page 16, where it's adding in the connection language, this time connecting violation of the instructor responsibilities back to rule 135, where that emergency suspension language has been added. Okay, so next we get into rules 300, 310, and 320. These are the denial, revocation, and the and suspension rules for the different private security provider classifications. 300 is specific to the alarm monitor. 310 is specific to the unarmed professional and the event and entertainment private security professional. And then in 320, you have the armed private security professional, the managers, and the instructors. So in each of these rules, you'll see the insertion of the suspension for the minimum standards. And it's built out in 2 layers. So first, just that authority to suspend. And remember, that takes the notice of intent to suspend, and the certification remains active until the final order of that suspension. And then it has the secondary layer of, if the department finds that there is a serious risk to the, serious danger to public safety, then they may use the immediate suspension authority and issue the emergency suspension order. And that process has been mirrored like the already existing process for the criminal charges. But I do want to point out the one difference, which is in Rule 320 and appears on page 21. And that's why it's formatted a little bit differently. So in this one, section 5C, so 5A and B are that straight suspension, opportunity to do emergency suspension. But C is capturing that very specific emergency suspension action when it is the armed private security professional or the firearms instructor who has lost their legal eligibility to possess a firearm and doesn't meet the minimum standards for armed certification. So that's that. The final rule in your packet is Rule 259-060-0380. Very much a process rule that lists out information. We've added some supporting process language to be consistent with our other emergency suspension actions. I do have information about the fiscal impact statements, but before I go into those, I wanted to pause to see if there was any discussion about the recommendations or questions about the rule language.
Member Flaw?
Ed Flaw, representing Alarm Monitoring. My question was, you said the intent to suspend, they're still able to be trainers, the instructors, and certify people. Once the suspension investigation is over and they are suspended, do you go all the way back to when they were first notified and decertify all of their students, or when they're finally suspended from that point forward?
Thank you for the question. And so this, if we're talking about the suspension of the instructor certification, are you asking for the violation of the instructor responsibilities?
Yes, once you've intended to suspend an instructor for violating, but they're still, you were saying they're still allowed to continue until it's finalized.
So right now, that has been the process up to this point, and that's why we're recommending the inclusion of the emergency suspension.
So that would, okay.
Order will immediately suspend their instructor certification, and they would no longer be able to teach with that certification.
Okay, perfect. Thank you.
Member Krieger?
Hi, good afternoon. Just a quick question. I apologize if I missed this in the explanation, but with the due process that follows an emergency suspension, are there any timelines associated with that?
Thank you, Jennifer Howell, for the record. Yes, when an emergency suspension order is issued, the order goes into effect immediately. The individual has then 90 days to request a hearing on that order to contest it. And then if they have submitted a timely request for the hearing, the request gets referred to the administrative hearings office, and then the timeline, I believe it all depends on what is able to be scheduled with that hearings office. But if after 90 days they have not requested a hearing, then it just remains an order in effect until it is resolved. And it could either be resolved through corrective action that the instructor takes, or it could be resolved through completion of the revocation process. I'll go on to the fiscal impact statements, but please don't hesitate to bring up any additional questions or discussion. Your memo includes the following information related to the required fiscal impact statement when filing an administrative rule change. The emergency suspension process does carry a cost for the departments. At this time, we can't precisely estimate the fiscal impacts of these rule changes, since emergency suspensions will only be issued when a provider is found to be in violation of the rules. While we expect a small increase in the number of emergency suspension orders based on these rule changes, any increase will result in additional administrative and legal expenses. Expenses include things like preparing and issuing the order, obtaining legal advice if needed, and managing any contested case hearings that may follow. We did not identify any other state agencies that could be potentially impacted by the administrative rule changes, nor local governments or general public. We did identify small businesses as individual private security professionals, private security executive and supervisory managers, and private security instructors, and entities, companies, businesses that employ private security providers all fall under that umbrella of a potential small business. So, of course, if a certification or license is suspended, the individual may experience a loss of income. Employers may face operational impacts due to temporary loss of the employee's services. But the actual financial impact will vary on a case-by-case basis and would only apply when there is a rule violation. So again, recognized cost, it exists already in our other parts of our rules with the ability to deny, suspend, or revoke. But it's just not something that can easily be measured. Again, happy to take any questions, and otherwise, when you all are ready, you have action items on page 24.
Elena Snyder, for the record, I just had one question. I know you said that there's no way to estimate the fiscal impact. Outside of the fiscal impact, is there any idea, it's potentially from a historical basis, how many of these might have occurred historically if this emergency suspension was in place in the past? If I'm making any sense whatsoever, I'm just curious to find out if there's been what the history is like behind this, and would we have had this rule been enacted, let's say even 3 years ago, would it have affected agencies then, and how many would it have affected?
Sure.
Susie Herring, for the record. If it was in effect 3 years ago, yes, I think we would have seen us handle some of our cases differently and being able to emergency suspend some instructors that wouldn't have continued on to teach individuals. That then at the end of the case, you're reviewing all those individuals to determine what the next step is for them. So it's, I guess, a little bit of a fiscal impact for them now versus later. With the suspension put in place, you won't have people that you would be looking at that potentially got training after recognizing that there's a problem there with that instructor's qualifications. So numbers wise, I mean, I could collectively say, but I don't know that it's accurate. I mean, I would be going off of what I see from my investigators, but I think it's the significant impact is those individuals that have received the training after we've noticed it. So the branch is like spread very wide and affects a lot of other people, and a huge liability for those agencies that continue to employ them and the public.
Absolutely, that's why I was curious to get kind of a better understanding as far as the rule change is concerned too, and
sure,
and protection, safety protection, of course, at the height of my inquiry. So thank you.
On the fiscal impact statement, is there any other discussions? So then by consensus.
Member Nakasone.
Oh, there it is.
Nakasone, unarmed, for the record. I'm just reading that first paragraph on the fiscal impact of the departments. So an increase is anticipated, but this would be a tool to functionally make the investigations proceed more efficiently. And then I noticed it says this will result in an increase in costs to the department. So the amount or the increase will go up, but wouldn't it also make you more efficient at getting through the investigations to be able to emergency suspend somebody and not have additional violations drag out as you're investigating?
Susie Herring, yes, I would agree with that.
And that can
Member
be-
Stone, I have a question. Is that okay? And then I promise we can get to a consensus, I'm sure soon. Is there any language that in the event the individual that's training, the instructor, who is hired by a company as an instructor, is there any language that if the violation occurs, that the investigation will go above and beyond the individual instructor level into possible violations on an executive or on an entity level by the hiring agency who might have been aware of the circumstances that led to a violation?
I can speak to that. Susie Herring, I think the language already exists with the executive manager responsibility. So we do that currently when we have cases, kind of looking at what level those civil penalties will fall on, whether, you know, an example of a professional who has a supervisor manager above them and they're aware of that happening. So we would look at each level above that instructor to find out who was aware of that, and we can hold those individuals accountable as well. It already exists.
Perfect. Thank you for putting that on the record.
Sure.
I move for consensus to affirm the fiscal impact statements.
Hearing no objections, that's a consensus, correct? Okay. Number 2, our vote. Looking for a motion to recommend the Board on Public Safety Standards and Training approve the filing of the proposed rule changes for 259-060, 0120, 0130, 0135, 0136, 060, 0300, and 0310, 0320, and 0380 as permanent rules.
Member Stone, I move.
Nakasone Alarm is second.
Call for vote.
Okay. Chair Lenzen,
Aye.
Member Berg,
Aye.
Member Krager,
Yes.
Member Flaw,
Aye.
Member Nakasone,
Yes.
Member Ralph,
Aye.
Member Schultz,
Aye.
Member Schneider,
Aye.
and Member Stone.
Aye.
Motion carried.
Dan Lenzen, thank you all for going through all of those pages and preparing this as well from the staff. Moving on to our next item is agency update.
Yeah, okay. All right, Susie Herring for the record. So I wanted to give you guys some updated statistics. So this last quarter for compliance checks, so we're talking July, August, and September, we had a total of 23 compliance checks in August, and that's 19 more than I reported at the last meeting because we were kind of mid-August at that point. And then September, we had 8. We haven't had any this fall yet. And then for complaints, we had 39 complaints. We opened 316 cases. We closed 195 cases. We recorded 687 trainings, and those trainings are trainings that we host as well as those that take training online. And then walk-ins, I like to report walk-ins and phones. Walk-ins, we had 123 walk-ins and 3,250 phone calls for a total of 209 hours. I was hoping to have some business services executive summary to speak to today. Unfortunately, we just met with them a few hours ago before this meeting, and we're still trying to track the information that's being provided to look at what our predictions will be for this biennium that we're in, to determine whether or not we'll be needing a fee increase. And I'll speak to that in a little bit further down my list here. I wanted to tell you about some staffing changes. So at the last meeting, we were recruiting for an OS2. We did hire an OS2 once Autumn got promoted into her position. So we hired Kat Meredith. Some of you may have spoken to her already on the phone. And then Caleb Mitchell, who we had in our program, has moved to front reception. So we currently have a vacancy for that position, but I'm gonna temporarily bring on someone for a time being to help us with our processing of applications. As I reported last time, we were caught up. Now we're about just over a month behind on applications for professionals. Managers and armed and instructors are about a week out, so much quicker on those just because of the volume. I reported last meeting that we had hired Crystal Maroney into our learning and development position, and so she's working her way through the ARM curriculum. We got the approval from the board to have the ARM work group, which we anticipate starting to gather that group together after the first of the year. But to her credit, she's not only looking at where kind of Steve left off, but she's looking at what we currently have and what instructors are currently using, as well as going back and reviewing the work that Julianne had completed and that work group too, to make sure that she has like a real clear picture of where we've evolved to and get us moving in the right direction. So we're still targeted to get that work group together, and we'll also be looking at administrative rules during that time too. What do those look like, and potential changes as it relates to the armed training and timelines for that. The website, I wanted to let you know that our website is going through some updates. Right now, those are required, federally required, so ADA updates to the website. So you may see some challenges there because some of the links sometimes are broken when staff is currently working on some of the updates. We're also trying to add, which we're terming web forms. And you'll see a web form right now with the complaint form. If you go online and file a complaint, that is a web form. And we're trying to look at other things that we do. What else can we use a web form for? For example, PS23s, can we use that as a web form? So Sherry Elwood, which is from our program, is working at a class in IT right now, and she's primarily working for our program, getting us set up and then moving on to different programs within the agency. So moving away from a lot of the PDFs that are out there, but hopefully we can still manage everybody's needs. And like I said, you'll probably see some changes there, font changes. That's another improvement that they're making for the ADA compliance. One of the things I wanted to talk about was the project update on the potential transition to a different database. I know I've been talking about it for a long time. We've been looking at different companies, but one of the things I wanted to share with you all today is I have been having conversations with one company, and they are coming back to me with another potential offer. And I think it's going to be doable, but my concern that I wanted to share with the group is the startup cost for it. So of course we're getting what it would cost for us annually to pay for this, but there's going to be a larger startup for that. And I would love to have further conversation about this, but one of the thoughts that arose during it is potentially doing a small increase for a period of time, whether that be 2 years or 3 years, to cover the cost of that startup. And this would mean that we would have all of our applications online. We would have online payment. We'd have instructors be able to go in and enter all the trainings that they're entering and potentially the PS23s as well. So it's a big wish list and they're willing to accommodate all of that and still have that outward facing like iris that you all can see as well. So I'm hoping that as we work through this and look at what the costs are, that I can come back to the committee and get support on the needs to potentially move forward with that. So more to come on that, but I just wanted to share with the current committee members that information. We held the first PI subcommittee today that we have had, the first one in the last 5.5 years or so, 6 years. It was great. We had that. We had 2 new members, and we're still soliciting for a 3rd member for the committee, as well as the other PI representative for this policy committee. They looked at a case today, which will end up coming to the policy committee at your next scheduled meeting. And then we kind of talked about a few things that came up on the round table, and more to come on that as well. Let's see, the last thing I wanted to update you all on was the House Bill 2183 work group. We have the 3rd meeting for that scheduled this Thursday, if any of you are interested in following that. We have been posting the agenda and the meeting minutes, as well as the YouTube videos of those meetings. They're a day delay because they're not live, but if you're interested, please go back and watch those. We have the 3rd meeting this week in hopes that it might be our last, but if we have to have a 4th, we will do that. But I think we're coming along pretty good. Jennifer has some potentially proposed rules to look at, but we still have a couple other agenda items to push through. So we will be meeting Thursday at 1 o'clock, I believe. So we'll be reporting on that at your next meeting as well in February. And just a reminder on the vacancies. So we have a board position vacancy. We have a retail policy committee vacancy, a public member on the policy committee vacancy, the Oregon State Bar for PIs. And I'd like to state on the record, some people are kind of confused about what that means. Any PI can apply for that. We just collect the applications and send them over to the Oregon State Bar, and then their board will have a meeting and vote on their recommendation to this department. And then leading into, we also have upcoming vacancies for manufacturing and hospitality, as Alex Stone and Ken Berg's terms are ending next January. So I welcome any questions that anybody has for me today.
Member Berg?
Ken Berg, for the record, going back to a discussion regarding open complaints and investigations, is there by chance any talk or future discussions or potential of updating and restarting the ethics bulletins on your website? As an instructor, I actually reference those quite extensively in class, and they're outdated by a couple of years.
Yeah, we ended that process years ago, and we have not implemented that again. It is time consuming for staff to do that. It's an extra duty for staff to post that every quarter. And the agency as a whole had gone away from the ethics bulletin. The CJ certification side actually has all of that information posted on their website in another format, and our program has not moved forward with that piece. So not currently or actively doing that, and I unfortunately don't have any plans to pick that back up, Ken.
Perfect, thank you. So download the few that are on there and save them for future trainings. Got it.
Questions?
Okay, I think I'll round us out. This is Marie Atwood for the record.
We do have a couple of certificates for our outgoing members, so Member Berg and Member Stone. I know you're both online today, but we do have some, congratulatory certificates for you, and we do thank you for your service to this committee. I want to thank everybody for for being here today. As you can tell from Susie's update and from all of the administrative rules you discussed, there is a lot going on with this industry, and we want as many of your voices at the table in the decision-making processes as possible. So for your work not only in this committee, but also in our subcommittee and in our work groups and all of the other kind of iterations that this community is taking right now, we just really, really appreciate your time and effort and participation. It's very clear that you care about what you do, and that makes our jobs here at DPSST a lot easier. So as far as agency-wide updates, there's not much going on. Well, there's always something going on, but there's not much I have to update you on for today's purposes. We're right in the middle of November legislative days this week. The only real thing of note that has occurred in our world was the Public Safety Subcommittee meeting yesterday. One of the big topics that's on everybody's immediate radar is state budgetary concerns. So I do believe they will be making some decisions regarding what any potential cuts will look like from state agencies. So we will obviously keep you up to speed with any of that as those updates develop. Otherwise, I don't think I have anything else from the agency-wide perspective.
Okay, our next meeting is scheduled for the last day of Fun and Debauchery, February 17th, also known as Fat Tuesday, the day before Ash Wednesday.
We'll have to get some catering.
And the Lenten season. So we should be all dressed in green and gold and purple on that day. So, and personally, Dan Winston for the record, thank you, Ken and Alex, for some very enlightening conversations. And can you force everyone to think a little bit harder? And Alex, we go way back, and you're amazing. Thank you.
We'll get these to you in the mail.
Thank you. It's been my honor to assist in this committee.
Thank you.
Meeting closed.
All right, thanks everybody.
Thank you.